We will now begin the mock trial. We'd like to introduce the speakers. IPHC Presiding Judge Kanno Masayuki, acting as Presiding Judge. IPHC Judge Nakamura Kyo, acting as a judge. IPHC Judge Katsumata Kumiko, acting as a judge. IPHC Judicial Research Official Yamaguchi Kazuhiro, acting as a research official. IPHC Judge Nakadaira Ken, acting as a technical advisor. IPHC Judicial Research Official Morifuji Atsushi as the technical advisor. Attorney at Law Abe Ikubo and Katayama Law Firm Hattori Makoto, acting as the plaintiff's counsel. Takamitsu Shigetomi, Attorney at Law Oebashi Law Firm, acting as defense counsel. IPHC Judge Ogawa Takatoshi, Judge Takatoshi Ogawa as narrator. They will be the ones who take the stage for the mock trial. In the patent infringement lawsuit, normally on the first date for oral argument, the complaint and the written reply are presented and basic documents and evidence are submitted. After the issues and evidence are sorted out, in preparatory proceedings using web conferencing and correspondence, oral argument is held, and the case moves on toward handing down of judgment. In this mock trial, you will see the second oral argument when the explanatory session will be held, and the third oral argument when the judgment will be delivered. The second oral argument is being held on September 20th, and in addition to the judges and the parties, the technical advisors and the judicial research officials will attend. Issues and evidence will be sorted out, and an explanatory session will be held to explain technical matters concerning the issues. Technical advisors are appointed for each case from among university professors and researchers from basic public institutions, and their role is to provide explanations on technical matters related to the issues. The judicial research official is a full-time court employee who investigates necessary technical matters under the order of the court. In this case, 2 technical advisors and 1 judicial research official are involved in the hearing together with the judge. In this case, since the issues and evidence have been sorted out in the preparatory proceedings by the authorized judge, who is a member of the panel, a statement of the results of the preparatory proceedings is presented to the panel, then an explanatory session is held, where the parties give oral explanations of technical matters and based on the results of the briefing. The technical advisors give explanations of technical matters. We will now begin the second oral argument. We have been sorting out the issues and evidence in the preparatory proceedings, and there is no dispute among the parties that the defendant's the position detector in form alpha, equipped with a standard stylus made of non-magnetic material, does not fall within the technical scope of the present invention, and that the defendant's position detector in form beta, in which the stylus made of non-magnetic material is attached, does belong to the technical scope of the invention. As summarized in the summary document, the issues are as follows. 1. Whether the manufacture and the sale of the defendant's stylus by the defendant constitutes indirect infringement by exclusive products under Article 101, Item 1 of the Patent Act. 2. Whether that constitutes indirect infringement by non-exclusive product under Article 101, Item 2. And 3. Whether the manufacture and sale of the defendant's position detector constitutes indirect infringement by non-exclusive product under Article 101, Item 2. And 4. The need for an injunction. In today's hearing, I ask for statements on the main points of each party's arguments. First, let's start with the plaintiff. First, I explain the main points of why the manufacture and sale of the defendant's stylus constitutes indirect infringement by exclusive products under Article 101 of the Patent Act. Since the defendant's stylus is used only for the production of the defendant's position detector in beta form, the manufacture and sale of the defendant's stylus by the defendant falls under the Act of Production of Transfer of a Product to be used exclusively for the production of the said product as defined in the Patent Act, which is a provision for indirect infringement by exclusive products. Even if this is not the case, the defendant's stylus is indispensable for solving the problem by the invention, and the defendant knew that the present invention was a patented invention through the notice from the plaintiff, and also knew that the defendant's stylus would be used to produce the defendant's position detector in the beta form. Therefore, the manufacture and sale of the stylus by the defendant falls under the act of producing or assigning any product to be used for the producing of the said product, and indispensable for the resolution of the problem by the said invention, knowing that the said invention is a patented invention and the said product is used for the working of the invention, as stipulated in the Act. Next, I explain the main reasons why the manufacture and sale of the defendant's position detector falls under the category of indirect infringement by exclusive products under the Item 2 of the Patent Act. Since both the stylus and the main body of the position detector are indispensable for resolving the problem by the invention, the position detector in form alpha is also indispensable for resolving the problem by the invention. As mentioned earlier, upon notification from the plaintiff, the defendant knew that the present invention was a patented invention and also knew that the position detector in alpha form would be used in the production of the position detector in beta form. Therefore, the manufacture and sale of the defendant's position detector by the defendant falls under the act of producing or assigning any product to be used for the producing of the said product, and indispensable for the resolution of the problem by the said invention, knowing that the said invention is patented invention and the said product is used for the working of the invention. That is all. The plaintiff. Now I ask the statement by the defendant. The plaintiff claims that the manufacture and the sale of the defendant's stylus falls under the Item 1 of the Patent Act, but the defendant's stylus is also compatible with the position detectors of the internal contact type and is not used solely for the production of the position detector in form beta. In addition, the plaintiff claims that the manufacture and sale of the defendant's stylus falls under Item 2 of the same article. But since the defendant's stylus is widely distributed in Japan, it is excluded from the products used for the producing of said invention according to the bracketed text in Item 2. In addition, since the defendant cannot know which user will use the stylus in the production of the position detector in form beta, the defendant did not manufacture and sell the stylus knowing that it would be used in the production of the position detector in form beta. Furthermore, the plaintiff claims that the manufacture and the sale of the defendant's position detector falls under Article 101, Item 2 of the Patent Act, but the position detector itself is not indispensable for the resolving the problem by the present invention. That's all. That concludes the presentation of the results of the preparatory proceedings. Now, based on the summary of the issues made, I first asked the plaintiff to give a technical explanation. First, I will explain the reason why the defendant's stylus constitutes indirect infringement by exclusive products. The present invention is limited to the case where the energized type, not the internal contact type, is used as a measurement method of the position detector, so the difference in the measurement method greatly affects whether this becomes indirect infringement or not. Please see the figure on the left side of the slide. In the internal contact type, the contacting position of the stylus comes into contact with the workpiece, and the rod tilts, causing the energized contacting portion inside the position detector to come off and cut off the current. Therefore, no electricity passes through the stylus, and the stylus must be tilted until the energized contact is removed, which reduces the measurement accuracy. On the other hand, the energized type shown on the right side of the slide measures the position of the workpiece by detecting the current flowing through a closed circuit formed when the contacting part of the stylus comes into contact with the workpiece to be measured. Therefore, the stylus must be made of a conductive material, but the measurement accuracy is much better than that of the internal contact type. As you can see, the measurement method and the performance are different between the two methods. The present invention is characterized by the configuration of the contacting portion of the non-magnetic material when the energized type is selected. In contrast, with an internal contact type position detector, it is not energized, so the problem of the stylus being magnetized by energization does not arise. The user would not be motivated to use the defendant stylus, which has an expensive non-magnetic contacting portion, for an internal contact type position detector. Since the world is full of contacting portions made of hard materials, users will use stylus with contacting portions made of less expensive material for internal contact type position detectors. Therefore, even if the defendant stylus is compatible with the internal contact type position detector, such use is not an economic, commercial, or practical use of the stylus, and the defendant stylus would be used only as a replacement part of the energized type position detector. Therefore, the manufacture and sale of the defendant stylus falls under the category of indirect infringement by exclusive products. Next, I explain the reason why indirect infringement by non-exclusive products is applicable to the defendant stylus. The present invention adopted feature B, a non-magnetic material containing tungsten carbide and a nickel binder, as a means of resolving the problem. Since the non-magnetic material A of the defendant stylus satisfies the material of the feature B, the defendant's stylus is essential for solving the problem. Next, I explain that the defendant satisfies the subjective requirement. The defendant is naturally aware of the user's usage situation that the defendant stylus is used for defendant's position detector in form beta and has been warned by the plaintiff. Therefore, the defendant manufactured and sold the stylus knowing that the present invention is a patented invention and that the defendant stylus is used for working of the present invention. Therefore, the subjective requirement is satisfied. Finally, the defendant stylus is a so-called custom-made product that can be attached only to the position detector manufactured by the defendant, so it is not something that is widely distributed in Japan. Therefore, the manufacture and sale of the stylus by the defendant constitutes an indirect infringement of the patent in question. Next, I explain the reason why indirect infringement by non-exclusive products is established for the defendant's position detector. In order to solve the problem by this invention, it is essential to adopt the energized type as the measurement method of the position detector and to form the stylus with non-magnetic material. Therefore, in form beta, where the defendant's stylus is attached, the position detector itself plays a part in the energized type, so that the defendant's position detector is also indispensable for resolving the problem by the invention. In addition, since the defendant sells the stylus as a replacement stylus for defendant's position detector, it goes without saying that the defendant manufactures and sells the position detector knowing that the stylus will be used in the production of the position detector in beta form. Therefore, the manufacture and sale of the defendant's position detector constitutes indirect infringement by non-exclusive products. The defendant continues to engage in the act of indirect infringement even today after the plaintiff has warned and sued. In order to stop and prevent the infringement of this patent, an injunction against the manufacture and sale of the defendant's stylus and position detector is necessary. No circumstance exists in which granting an injunction would be harsh to the defendant. Therefore, the request for an injunction should be granted. That's all.
Thank you very much. Now I'd like to have the defendant give a technical explanation. First, the defendant will explain that the plaintiff's argument regarding Article 101, Item 1 of the Patent Act is groundless. As illustrated on this slide, the defendant's stylus is compatible with the internal contact type position detector manufactured by the defendant, and in fact, there are users who use it attached to the internal contact type position detector. The plaintiff claims that the user would not intend to use the defendant's stylus with a contacting portion made of cemented carbide for the internal contact type. However, the cemented carbide used as the material of the defendant's stylus has excellent wear and corrosion resistance, and it has the advantage of preventing measurement errors due to wear and deformation caused by repeated contact with the workpiece, such as when the workpiece is hard, even with an internal contact type position detector. So there is a need to use a stylus made of cemented carbide with the internal contact type. Since the defendant's stylus has an economic, commercial, or practical use as a stylus for the internal contact type, it does not fall under the category of used exclusively for producing of under Article 101, Item 1 of the Patent Act. The plaintiff also claims that the manufacture and sale of the defendant's stylus constitutes indirect infringement under Article 101, Item 2 of the Patent Act. But the defendant's stylus is no different in any way from those that have been widely used for position detectors in the past. Therefore, it's a product widely distributed within Japan, as indicated in parentheses in the article, so its manufacture and sale does not constitute indirect infringement. Furthermore, the defendant did not manufacture and sell the defendant's stylus knowing that it would be used for the working of the present invention. As illustrated in this slide, the defendant sells the defendant's position detector with a stylus made of SAS, which is a magnetic material equipped as a standard equipment. Also, the defendant does not know exactly how many cases the defendant's stylus has been used with the defendant's position detector, or at what rate it has been used. Therefore, the defendant has no way of knowing that the defendant's stylus is used for the position detector in beta form. The plaintiff claims that the manufacture and sale of the defendant's position detector constitutes indirect infringement, but it is clear that the defendant's position detector is not indispensable for solving the problem by the invention. In other words, it cannot be said that this position detector by itself prevents measurement errors due to wear, deformation, or magnetization caused by repeated contact and separation of the stylus from the workpiece. Therefore, the only characteristic part that directly brings about the unique configuration that characterizes the characteristic technical means of the invention is the stylus, not the position detector. Finally, I state why an injunction against the manufacture and sale of the defendant's stylus and the position detector should not be granted in this case. As already explained, the defendant's stylus has a lawful use of being attached to an internal contact type position detector. Nevertheless, if the manufacture and sale of the defendant's stylus were to be completely restricted, the lawful use of the stylus would also be restricted, and such a consequence would be unjustified and inappropriate. There is no reason why the manufacture and sale of this position detector, which has only a publicly known configuration, should be restricted. Thus, the plaintiff's request for an injunction is an excessive request and should not be granted. That is all. Thank you. the main judge, the associate judge, will ask some questions. I'd like to ask both parties to confirm the relationship between the material of the contacting portion of the stylus and the position detector for the internal contact system. What's the understanding of the defendant in this regard? The defendant understands that when the hardness of the workpiece is high, it's desirable to increase the hardness of the contacting portion, so using a stylus made of cemented carbide would naturally be included as one of the choices for a person skilled in the art. How about the plaintiff? If you just focus on hardness, there are other materials that can be used for the contacting portion which are harder than cemented carbide, such as ruby. Since cemented carbide is conductive and has high utility in an energized system, I understand that it's not common to use a stylus made of cemented carbide for an internal contact system. Now, could one of the technical advisors please explain this point? Yes, technical advisor Nakadaira will provide an explanation. In principle, I think the energized type is more accurate, but even with the internal contact type, micron level measurement accuracy is required, so whatever the detection method, the contacting portion is required to be made of material that is resistant to wear and deformation. However, the choice of the material to be used as a stylus for an internal contact type position detector is usually based not only on hardness, but also on other material characteristics, the actual processing environment, the durability of the stylus as a whole, including the joint strength between the rod and the contacting part, and the material of the workpiece to be measured. Therefore, the stylus is not limited to a specific material just because it is an internal contact type. Thank you. Next, I'd like to ask the technical advisors to explain the relationship between the position detector in the energized system and the non-magnetic stylus. The plaintiff claims that both the use of the energized type and making the stylus non-magnetic are essential to solve the problem of the invention, which is to provide a position detector that enables accurate position detection. Concerning this problem, what is the technical relationship between the position detector and the stylus? Technical advisor Morifuji would like to explain. In a work environment where a magnetic field is expected to be generated, it's technically natural to use a stylus made of non-magnetic material, regardless of whether the detection method is the internal contact type or the energized type. So non-magnetic and detection method are unrelated. It's true that a stylus made of magnetic material may become magnetized when it is repeatedly energized and de-energized by touching the workpiece, so the feature of the present invention is to make the stylus non-magnetic even in a work environment where a magnetic field is not expected to be generated. It can be said that this feature can be utilized only when the detection method is the energized type. Even in this case, though, you only need to make the stylus from conductive non-magnetic material, and the structure of the energized type position detector itself is the same, regardless of whether the stylus is magnetic or non-magnetic, and its function remains exactly the same, regardless of whether the stylus is magnetic or non-magnetic. Therefore, there is no direct relationship between the structure of the position detector and the material of the stylus, and it would be common to regard them as physically and functionally independent components. Thank you. That is all from me. Does the judicial research official have anything to say? Since the time for the trial seems to be limited, I have nothing in particular. Since there seem to be no other questions, this concludes the explanatory session for today. Have all the arguments and evidence of both the plaintiff and the defendant been submitted by today? Yes, there are no other arguments or evidence from the plaintiff. The same goes for the defendant. I will now conclude this oral argument. The court will render the judgment based on the contents of the explanatory session and the arguments and evidence presented until today. The judgment will be rendered at 2 p.m. on October 20th. Is there any possibility of resolving this case through negotiations? Yes, the plaintiff has no objection to setting a date for settlement negotiations. Same thinking at the defendant side. Okay, we'll set the September 27th, 2 p.m. As the date for settlement negotiations. The court disclosed its conviction based on the results of the hearings to date, and on the settlement date, based on this conviction, discussions were held toward a negotiated settlement. The plaintiff indicated a willingness to settle based on the court's conviction, but the defendant indicated that it would seek the judgment of a higher court and it would be difficult to reach a settlement based on the court's conviction or impression. The court decided that it would be difficult to proceed with the settlement talks and terminated the settlement talks. Today is the date for the pronouncement of the judgment. The judgment will be rendered orally based on the judgment document. In light of the nature of the case, the court has decided to state the gist of the reasons in addition to reading the main text. Now I will render the judgment. The main text. Number 1. The defendant shall not manufacture or sell the defendant's stylus. Number 2. The remaining parts of the plaintiff's demand are dismissed with prejudice on the merits. 3. The court costs shall be divided into 2 equal parts, with the defendant to bear one half and the plaintiff to bear the other half. 4. This judgment may be provisionally enforced as far as paragraph 1 is concerned. Now I state the summary of the reasons. First, whether the manufacture and sale of the defendant's stylus constitutes indirect infringement under Article 101, Item 1 of the Patent Act. It is found that the defendant's stylus can be used by attaching it to a position detector with an internal contact system, and there is no evidence sufficient to admit that such use is not an economic, commercial, or practical use of the defendant's stylus. On the contrary, even when the stylus is used in a position detector with an internal contact system, it's recognized that it has the advantage of preventing measurement errors caused by wear and deformation due to repeated contact with the workpiece, and that such use is an economic, commercial, or practical use of the stylus. Therefore, such use is found to be an economic, commercial, or practical use of the stylus. Therefore, the manufacture and sale of the stylus by the defendant do not constitute indirect infringement under Article 101, Item 1 of the Patent Act. Next, whether the manufacture and sale of the stylus constitutes indirect infringement under Article 101, Item 2. Attaching the defendant's stylus to the defendant's position detector constitutes the production of the position detector in beta form. In addition, since it is found that the defendant's stylus is a custom-made product that can only be attached to the position detector manufactured by the defendant, it does not constitute something that is widely distributed in Japan. Therefore, the stylus can be found to be a product to be used for the producing of the position detector in beta form. Parenthesis 2. The problem that this invention solves is to provide a position detector that enables accurate position detection by equipping it with a stylus that is durable and that does not cause measurement errors. And as a means of solving this problem, the invention adopts a configuration in which the contacting part of the stylus is made of a designated non-magnetic material in a position detector of the energized type. The defendant's stylus has the same configuration as that of the above-mentioned configuration, which is the means of solving the above-mentioned problem of the present invention and thus falls under the category of indispensable for the resolution of the problem by the present invention. Parenthesis 3. On May 1, 2020, the defendant received a notice from the plaintiff stating that the position detector to which the stylus is attached falls within the technical scope of the invention and that the manufacture and sale of the stylus constitutes infringement of the patent, which made them recognize that it is highly likely that the defendant's stylus is used for the working of the present invention. Therefore, the manufacture and sale of the defendant's stylus constitutes an act of producing and transferring, knowing it is used for the working of the invention. According to the above, the manufacture and sale of the defendant's stylus by the defendant constitutes indirect infringement under Article 101, Item 2 of the Patent Act. Number 3. Whether the manufacture and sale of the defendant's position detector constitutes indirect infringement under Article 101, Item 2. The present invention provides a position detector that enables accurate position detection by equipping it with a stylus that is durable and does not cause measurement errors. As a means to resolve that problem, it employed the configuration of tungsten carbide and nickel binders for the stylus contact portion for an energized position detector. The main body of the defendant's position detector is a separate and independent component from the stylus, which consists of the above-mentioned structure and therefore does not constitute something indispensable for resolving the problem of the invention. Therefore, the manufacture and sale of the defendant's position detector by the defendant does not constitute indirect infringement under Article 101, Item 2. 4. Necessity of the injunction. The defendant's stylus is indispensable for solving the problem of the invention, and it's recognized that there currently exists a situation where there's a high probability that infringement of the patent right will be caused by the transfer of the stylus. Therefore, it's recognized that there's a need for an injunction against the manufacture and sale of the defendant's stylus in order to stop or prevent infringement of the present patent right. Based on the above reasons, the court has rendered the judgment as stated in the main text. This concludes the mock trial. Thank you very much for watching.
This concludes the mock trial. Thank you very much for acting on the stage.